Thank you very much for joining today. My name is Pete Moloney. I am a Principal Associate in the London office of the Insurance Department. My background is coverage of general nature. I do UK property, international property, construction, professional indemnity, cyber and political violence. I'll be talking to you today about a burden of proof. A couple of housekeeping points I need to raise. The recording will be available afterwards on our website, and I understand that if you would like to ask a question at any stage, you can just pop the question into a Q&A box, which I'm not quite sure how the technology works, but I understand that the questions will then be fed through to me by my colleague at the end. The agenda that we're going to follow, we're going to start off with a general rule for burden of proof. As ever, we have some exceptions, and then we'll move on to looking at all the risks policies before then finishing with process of elimination, willful act of the insured, and any special provisions that are in the policy. So starting first with the general rule, the insured has the burden of proving that the loss was caused by a peril insured against. They need do no more than that. So in other words, an insured just has to prove that they've had a fire, and obviously in the case of a fire, it's going to be fairly easy to do. They don't need to prove precisely what the cause of the fire was. They don't need to carry out any investigations. So for example, if the insured believes that the fire was caused by an electrical fault, they don't need to carry out their own investigations to prove that that was the cause. All they need to do is prove that they have had a loss that is within an insured peril. As ever, there are exceptions. Once the insured has proved that the loss was caused by the general peril insured against, it is for the insurer to prove that the exception is operative. So I've put a quote here, and I'll explain in a second why why part of it is highlighted in red, but it explains loss or damage arising from any cause whatsoever on land or water, save and except. And then this is the exception, loss by theft or dishonesty committed by any servant of the assured. So the bit that I've highlighted in red is the bit that the insured has to prove. They have the burden of proof and must show that the loss falls within a general peril, that is loss or damage arising from any cause whatsoever on land or water. The bit that's not in red, the burden is then on the insurer to prove the facts which bring the case within the exception. So in other words, that theft or dishonesty was caused by a servant of the insured. Should anyone ever have the case of Hurst or Evans recommended to them to support insurers, this is where this clause comes from. The case has been heavily criticised because the judge found that the burden was on the insured to prove that the loss or theft, the theft was carried out by a servant of the assured, and that is wrong, as you can tell, has been heavily criticised. So Hurst v Evans is not a case to rely on. What about an exception of an exception? Well, there are always exceptions of exceptions. The example I have here, I haven't given a specific example in terms of wording, so I didn't want to make this slide too long, but an exception of an exception is this insurance does not cover risk X, which is the exception, except where Y applies. So Y is the exception of the exception. There is a case where this was looked at. It's Omega Proteins Limited v Aspen Insurance UK Limited. This was actually one of my cases. We were successful in our claim against Aspen Insurance, and I hope I haven't lost anyone from Aspen Insurance on the call now as a result of that. But what the court found in that case was that the insurer has a double burden. They've got to prove both the exclusion from the cover, so that's X, and they then have to prove that the exception to the exclusion did not apply, so that's Y. So I think at this stage it would be handy just to sum up what I've said so far. There's always going to be some overlap on the burden. So taking that jewellery case as an example, the insurer has the initial burden of proving that the loss was caused by the theft or dishonesty of a servant of the insured. So they've got the initial burden, but it obviously goes without saying that the insured is going to do all they can to disprove the theory to a stronger extent, can disprove the argument being advanced by insurers. So although they don't actually have the burden, they'll be carrying out just as much, if not more so, of the investigations that the insurer is going to carry out. So what we're talking about here is the initial burden. If the insurer wants to rely on the exception, they will have to be the one that lays out their arguments with sufficient evidence such that you would be able to discount any evidence that the insured might be able to put forward themselves. It's often suggested that all risks policies are different. What we've been looking at so far, taking the jewelry case as an example and the Amiga proteins as well, is a commercial combined type policy. As I say, it's often suggested that all risk policies are treated in a different way by their nature. They're not. They're treated no differently. The burden is on the insured to prove that the loss was accidental, and it would then be for the insurer to prove that the loss was caused by an accepted peril. So it's exactly the same as the commercial combined policies, exactly the same as a household policy. They're not treated in any different way. We then come on to process of elimination. What do I mean by that? Well, it's simply that if the insured has advanced an argument that the loss was caused in a particular way, and the insurer has advanced an argument that the loss was caused by an accepted peril, or an exclusion might apply, then you've effectively got two competing causes. The process is the same in the sense that the party bearing the burden of proof may be able to discharge it by a process of elimination. But you do have to remember in those contexts that it's unlikely to be discharged if the party seeking to establish that an event has occurred was inherently improbable. So the example I've put there is that the ship was unseaworthy, sank, and the owners argued that it collided with a submarine. Now, of course, that could happen. It's going to be very difficult for the insured to prove that that was the case, but it's a more improbable argument than just arguing that the ship was unseaworthy. I always urge caution when you're going down the process of elimination route. What I've done here is I set out 3 cases. I'm not going to go through these 3 cases or even read the what I've put there on the slide, just because it's quite wordy. But what these 3 cases show is that the court in these 3 instances have always approached the process of elimination in a slightly different way. These cases are all good law at the moment, but because what they say is all slightly different, I think it's only a matter of time before one of them is overruled, such that you can't rely on it anymore. So process of elimination is one of those processes where you have to make sure that the argument you're advancing is probable. You've got to get all of the evidence you can, so that you're not just really looking at advancing a cause that might appear just slightly better than the one that the other party is advancing. Because the reason I say that is because what will happen is well, rather, let me phrase it the way the question says there. What if the court favours neither of the alleged causes? So you haven't been able to satisfy the burden of proof, whichever party you are, be it the insured or the insurer. In this, to give an example, the insured argues the ship collided with a submarine. The insurer argues that the ship was unseaworthy, which would be an exception. Both parties have to advance evidence sufficient to satisfy their burden of proof and to persuade the court. This was looked at in the case of European Group Limited against Chartis Insurance UK Limited. And the answer simply is that the insured would fail. If they haven't been able to satisfy their burden of proof that the loss falls within an insured peril, no matter how strong or weak the insurer's arguments, then the insured would just fail against the insurers. And I've just put there that the court may be left in sufficient doubt, such that even if it rejects the insurer's explanation, it cannot say that the insured's explanation is more probable than any alternative uninsured explanation. And that's lifted directly from the case, which is why it's a little bit wordy and perhaps hard to follow, but it says what I was saying a moment ago, that the insured's burden of insured may not be able to satisfy their burden of proof. And as I say there, in those circumstances, the insured's claim will fail on the burden of proof. These final 2 points are going to be easy to deal with. Willful act of the insured. If the insurer chooses to plead positively that the insured deliberately destroyed the property, the insured property, he will assume the burden of proof of proving that assertion. That's basically akin to fraud. And if an insurer is going to allege fraud, they have the burden of proof they have the burden of proof. Nevertheless, the same still applies. An insured must still prove that the loss was caused by an insured peril. So even if the insured has a fire, they need to prove that they have satisfied that there was an insured loss. Then it's for the insured to prove that, or to find out, to argue that they believe the insured destroyed the property. The final point to touch upon is just special provisions in the policy. I've had many cases over the years where for one particular policy year, the policy wording has been slightly different. For example, it could be 2008-9, would have one policy, then 2010-11, a different clause went into that policy, which was then taken out in 2012-13. And it's sometimes been the case that claimants and justice haven't been aware that the policy wording has had a minor change. It could be that the wording, for some reason, for that year has reversed the standard burden of proof. Always check as well to see. I have seen endorsements where the standard burden of proof rule has been reversed. So do always check the policy wording if you think there's any chance that it may be one where the general burden of proof has been reversed. It's a relatively simple and concise topic, so that is all I have to say. I would now welcome the opportunity to answer any questions you may have, which my colleague will be feeding to me.
Pete, yes, we do have a couple of questions. The first one is, you mentioned when talking about an exception to an exception, the case of omega proteins. I wonder whether you're able to elaborate and tell us a little bit more about that case.
Yeah, I didn't want to put the actual clause into the slide just to make it too wordy, because it does include the insuring clause and the exception. But the insuring clause was all sums which the insured becomes legally liable to pay for damages arising out of accidental loss of or damaged property caused by any product. So that's the burden of proof of proving that rests with the insured. But then the exception was insurers will not indemnify against any liability arising out of contract or agreement unless such liability would have attached in the absence of such contract or agreement. And just to give a bit of background facts, which I haven't actually got in front of me, but I can try and do from memory, but the Omega was a meat processing company. So basically whatever is left after McDonald's are finished with the cow gets passed to a company such as Omega, who then would take everything left of the cow and apparently turn it into things like makeup and all that sort of body cream and so on. There's category, again, I can't remember if it's numbered categories or lettered categories, but there was category C, for example, was animal products that can't pass into the human chain. And category A was products that could do, or the other way around. And through a mix-up, they passed the wrong products into the wrong chain, and it meant that when it was mixed with other products, then the whole lot had to be disposed of because it contained products, the category C, that should never go into the human chain. The category C instead becomes dog food and so on. Aspen declined the claim because they said, sorry, just take a step back, the party to whom Omega provided the meat products brought a claim down a contractual chain, and so just for a simple breach of contract, and Omega made a claim under their the policy against Aspen, who were the insurers of the final party in the contractual chain. And Aspen had argued that because they were being sued for breach of contract, their liability therefore arose out of contract or agreement. And whereas we sought to argue that the liability would have attached because they still would have been negligent, regardless of the contract, for damage to property and the losses that flowed from that. And I always remember our barrister saying to the judge that it would be akin to effectively saying to a claimant, thank you very much for suing me for breach of contract, but can you also sue me in tort, because then I can get it through my insurance policy. So I hope that answers that question, whoever that was.
Thank you, Pete. One other question that comes to us from Martin Reeves. He asks, is an exception of an exception similar to concurrent causation, would you say?
No. No, I can see why you would ask that argument, Martin, but it is a good question, Martin. I think off the top of my head, I'd be inclined to say no, because an exception of an exception isn't the same. You've got concurrent causes, effectively, which you could argue were competing. Whereas the exception of the exception, you have your exception, and then you have something that would get around that exception. Whereas I think when you've got concurrent causes, one doesn't get round the other. It's a question of the two causes are concurrent. One doesn't knock the other out. I will be honest, it's a question that I will actually give some thought to, but I'm afraid off the top of my head, my answer would be no. I don't think there'll be any overlap between or any similarity between the two.
There is a question that's come to us anonymously, but it's wondering whether there's any view that's held here on this particular issue. They've seen some policy wordings of late where insurers are expressly trying to reverse the burden. So, for example, the burden of proving this exclusion doesn't apply falls to the insured. And the question is whether we think this is binding and enforceable.
Yes, because you can reverse the burden of proof if you want to in your policy. That's why there may be why my final slide about the special provisions. It's not a sort of legal requirement. It's if you want to, you can contract for any provision that you want. So if you would like to reverse the standard burden of proof, you can do so. And as I say, I've seen endorsements before. Not many of them, my 18 years of practicing, but I have seen endorsements before in policies where the general rule has been reversed. Now, no, I don't know the reasons behind it. That's for the underwriters to comment upon. But I have seen that before, and there is nothing wrong with doing that.
Thank you, Pete. Well, that concludes our questions for the time being. So back to you.
Thank you. We'd be very interested in your feedback to let us know how we got on today. We would also be interested in any future topics you would like us to talk about. So please do fill in the Q&A tool beneath. When the talk finishes, we'll just give you a couple of minutes just to fill that in. Just to flag that my colleague Neil Innes will be speaking to you on the 23rd of July, so week today at the same time, on aggregation. And if anyone would like to join the webinar, then please do register on our website. All that remains for me to do is to say thank you very much for joining us today.